The case of NRL Investments Pty Limited and Singtel Optus Pty Limited is one that illustrates the challenges that face the Australian legal system in the new digital economy. In particular, how does the law provide an effective balance between the protection of copyright owners versus the need to keep pace with the growing consumer demand for ubiquitous access to information and media? The case centred on potential copyright breaches caused by the use of an Optus service called TV Now. This service offered sports lovers an opportunity to record and view broadcasts of games using their mobile devices from the AFL and the NRL. The two leagues had previously granted Telstra the exclusive internet and mobile rights to these games, and so TV Now provided a competing offering that severely impacted the value of their respective arrangements. Questioning whether Optus was infringing their copyright, the NRL commenced an action in an attempt to protect these exclusive rights. At federal court in the first instance, the court found in favour of Optus. However, this was later overturned on appeal to the full federal court. In allowing the appeal, two primary issues were considered. The first issue centred on the question of which party made the recording or copy. To provide the service, Optus had been transcoding, or that is converting to a digital stream, the terrestrial broadcast for the various Australian TV networks. Using the TV Now service, a user would initiate the recording of a broadcast, which would trigger the previously mentioned digital streams to be stored onto Optus infrastructure for a period of 30 days. 4 separate streaming formats were stored, enabling Optus customers to play back the recording on a range of PC and mobile devices. In light of Optus's heavy involvement in the act of recording, storing, and streaming the broadcast, the court found that both Optus and the subscriber were jointly and severally responsible for the act of copying. The second issue considered by the court was whether the recordings were made for private and domestic use. Section 111 of the Copyright Act provides an exemption so that the making of a recording does not infringe copyright of any work in the film or sound broadcast, where the recording is made for private and domestic use for the purpose of watching or listening at a later time. Whilst it also extends the exemption to loaning of such recordings to family members or members of the household, it does not apply to any commercial or public use. Here, the court found that Optus's clear purpose in providing the TV Now service was to derive such market advantage in the digital TV industry as its commercial exploitation could provide. Consequently, Optus could not invoke the Section 111 exemption and was found liable for copyright infringement. The case has subsequently resulted in a degree of uncertainty as to what are the legitimate boundaries of the time-shifting exception. Such uncertainty remains a significant obstacle to those online providers seeking to provide fair dealing or flexible dealing services to customers. The court had even acknowledged this point directly, accepting that different relationships and technologies could have resulted in alternative conclusions to the question of who makes the copy. As a personal example, I have a home theatre PC capable of recording content for playback on devices within the home or for streaming to devices such as my mobile when I'm travelling for work. The ratio in the TV Now case indicates such use would fall within the scope of the time-shifting exception. In an alternative scenario, if I was to use a commercially cloud-provided service to store and make available for streaming the video and audio content to multiple devices, the question as to who makes the copy and whether it's for private and domestic use is not so clear. Whilst the Australian Law Reform Commission is considering the impact of cloud technologies and associated offerings, Parliament is yet to take further action. It's my opinion that this lack of action fails one of the primary objectives of the Copyright Amendment Bill of 2006, that being the need for copyright law in Australia to keep pace with developments in technology and rapidly changing consumer behaviour. So let's recap some of the outcomes from the Optus TV Now case. First, Section 111 of the Copyright Act does provide the time-shifting exception to allow the recording of broadcasts for private and domestic use at a later time. 2. The exception does have some limitations, primarily involving commercial or public use. And 3. There does remain some uncertainty as to the boundaries of the exception.